Welcome to our PHI Consent Tool video series funded by the Michigan Health Endowment Fund. These videos were developed to help you understand the laws and best practices for sharing protected health information, or PHI. This video and the PHI Consent Tool have been prepared for educational purposes only. Nothing presented here or in the tool is intended as, nor should be relied upon as legal advice. Any party that is contemplating the use or disclosure of protected health information, or PHI, for any purpose is encouraged to consult with its legal counsel. The word consent is used frequently and is meant to refer to an individual's permission to share their PHI, rather than permission for treatment. While the term PHI generally relates to the federal law HIPAA, or the Health Insurance Portability and Accountability Act, we use PHI to address all health information that is protected by both state and federal law. This presentation was developed in conjunction with the PHI Consent Tool, an alternative resource to help clinicians, payers, and others navigate the laws and regulations around when consent is necessary to share PHI. In this video, we aim to help you understand the regulations around sharing PHI when it comes to substance use disorder, also known as SUD PHI. We will also address when and how to use the Michigan Behavioral Health Standard Consent Form, also known as MDHHS 5515. When it comes to sharing SUD PHI, there are two relevant laws you should be aware of. Title 42 Code of Federal Regulations Part 2, or Title 42 CFR Part 2, and the Michigan Mental Health Code. Title 42 CFR Part 2 is a federal regulation that protects the privacy of SUD patient records. The originating legislation was enacted in the 1970s to protect an individual's right to privacy and protect patients against the stigma that may cause them to avoid SUD treatment. Title 42 CFR Part 2 applies to any program that involves SUD education, treatment, or prevention, and that is regulated or assisted by the federal government. Title 42 CFR Part 2 rules say that an individual must provide written consent to authorize the sharing of SUD PHI, and that there are very few instances where SUD PHI can be released without an individual's written consent. Not everyone is subject to Title 42 CFR Part 2 rules. However, everyone in Michigan is subject to Chapter 2A of the Michigan Mental Health Code. The Michigan Mental Health Code clearly states that written consent must be obtained to share SUD PHI unless the disclosure falls under one of 7 statutory exceptions. For medical emergencies, for specific court orders, for mandatory reporting, in duty to warn situations, when it has been de-identified for research, for financial audits, or for program evaluations. For the research, financial audit, and program evaluation exceptions, the subject of the information must be de-identified. However, there are 2 exceptions when this may not be required. When the identification is essential to achieve the purpose for which the information is being sought, or if preventing the identification would clearly be impractical. Please note, if the subject of the information is likely to be harmed by the identification, these exceptions do not apply. So, in Michigan, regardless of whether you are a Title 42 CFR Part 2 program or not, you must obtain written consent to share SUD PHI, except in the cases of these 7 statutory exceptions. Please note, the Coronavirus Aid, Relief, and Economic Security Act, or CARES Act, was enacted in March 2020 and made significant changes to the federal SUD privacy law. The Substance Abuse and Mental Health Services Administration, or SAMHSA, has until March 2021 to implement appropriate regulations. In July 2020, additional changes were made that are effective in August. For now, we advise following the consent requirements under the Michigan Mental Health Code, since it provides more protection to the individual, and Michigan law requires that you follow the legislation that provides the most protection. When requesting consent to share SUD PHI in Michigan, all clinicians must use a consent form. The consent form must align with the requirements contained in both Title 42 CFR Part 2 and the Michigan Mental Health Code. In the past, each clinician developed their own consent form, but the differences between forms made sharing information across the healthcare system difficult. To address this problem, the Michigan Department of Health and Human Services, or MDHHS, created a standard consent form for sharing behavioral health and SUD PHI, named MDHHS 5515. All clinicians and organizations across the state of Michigan are required to honor and accept MDHHS 5515 when presented with it, unless you are held to more stringent requirements under federal law. In addition to honoring the form, clinicians must also use the form to request the release of behavioral health and/or SUD-related information for Medicaid beneficiaries. If you are a clinician or organization that does not serve Medicaid beneficiaries, you may use an equivalent form, but you must honor MDHHS 5515 when presented with it. To recap, in the state of Michigan, an individual's written consent must be obtained to share SUD PHI unless the disclosure falls under one of the 7 statutory exceptions: medical emergencies, specific court orders, mandatory reporting, duty to warn situations, when it has been de-identified for research, financial audits, or program evaluations. Clinicians must use MDHHS 5515 when requesting the release of PHI for all Medicaid beneficiaries. All clinicians must honor and accept MDHHS 5515 when presented with it. You can learn more information about sharing PHI in the state of Michigan with the PHI Consent Tool and companion documents found at www.michigan.gov/PHI Consent Tool and by visiting www.michigan.gov/BH Consent. You can email us anytime at mi.consent.help@alterum.org. Thank you.